The past 10 years of tort reform in Texas has radically changed the landscape of insurance and your rights as a victim in any case against an insurance company. But if tort reform is such a good thing, then why have insurance rates gone up even after its passage? On today's program, Houston attorney Jim Walker joins us to discuss tort reform and your rights. I'm Matt Topolsky, and this is Legally Speaking. Jim Walker has been rated one of the top personal injury lawyers in Houston by Inside Houston magazine, and he's been a practicing attorney for over 30 years. And it's my pleasure to introduce him at this time, Walker, Texas lawyer. How are you, sir?
I'm good, Matt. How are you?
I'm doing very well. You know, tort reform is a subject that's been on everyone's mind, especially people in Austin working in the legislature. And over the last 10 years, there's been a huge push for tort reform here. So, recapping what has happened in the last 10 years, where are we today?
Well, let's back up to whether or not it's been on everyone's mind.
Yes.
It hasn't been. It's been on the minds of those people who are in charge of changing laws and making trouble, and the insurance companies. But it hasn't been on the minds of everyday people, the people who are affected by it. Mm-hmm. And it should be, because tort reform has been devastating to those people who have been injured in accidents, those people who have been hurt by medical malpractice, and people who have civil cases in the civil courts. It has totally, I think, totally gutted our civil system.
Well, before we go into that, explain to everyone at home what tort reform is, if you would.
Well, first of all, let's discover what a tort is.
Okay.
There's a lot of folks out there that think it may be a dessert or something.
Yes.
A tort is a English term, Old English term, referring to an injury claim, a claim for something that you've been wronged, when you've been treated wrongly by someone, and it falls under a liability or a tort claim. Now, tort reform was started here in Texas 12 years ago or so, and the first blast across the bow, as it were, was tort reform for medical malpractice claims against doctors and hospitals and medical providers, where they capped the recovery at $250,000 for non-compensatory damages, which means that they could pay the medical bills and any other costs, but only $250,000 for pain and suffering, mental anguish, and general damages, personal damages, bills aside. Well, for over 200 years, this nation did just fine. We did fine just by having the juries decide how much to pay for a claim. The Constitution outlines it, and I feel it's a violation of the Constitution, honestly, to pass legislation to cap jury verdicts when the Constitution allows the juries to decide.
Well, how did we get to this point? What was the excuse that was being used for tort reform in the first place to take the power out of the jury's hands?
Well, the excuse was, in medical malpractice at least, is that doctors were being heavily burdened by expensive medical malpractice insurance sold to them by malpractice insurance companies. And they were, and they still are. Okay? They still are. Medical malpractice claims were never really out of control, even 12 years ago when this all started, or they certainly are not out of control now. There's hardly anything such as a medical malpractice claim anymore. They've virtually eliminated those because they've driven lawyers away from representing people. They have used their propaganda to affect juries and how much they would award, and have essentially eliminated it as a cause of action. Well, there were safeguards in place without the tort reform, where a judge could issue what's called a remititure. If he thought that the jury was out of control and awarded too much money, the judge could take some of it back and say, that's too much, which I have a problem with as well. The judge doesn't have the authority, should not have the authority to do that.
Right.
The jury is what the jury is. They decide. A jury of our peers,
Yeah.
our neighbors.
Right.
The Constitution provides for that. You know, people, when they think about our constitutional rights, they think about the freedom of speech, and they think about the right to bear arms, and the right to gather and protest. All fabulous, wonderful rights. We should hang on to them dearly. And they think of civil rights as being a right that you have in criminal court, not to be prosecuted by unjustly prosecuted, and to have a jury of your peers decide your guilt or innocence. And that's all well and good as well.
Yeah.
Those rights are in place, of course, only if we protect them.
Right.
But your right to a civil trial, your right to have your grievance aired in court, and to be compensated for injury that you may have suffered contractually or physically, has been gutted.
Right.
By the legislature and by some of the courts.
We need to take a break. If you would, stay with us, please, because I want to expand upon that and why that's happened in the legislature.
Okay.
So more with Jim Walker in a moment here on Legally Speaking.